This is your man Miles. Welcome, welcome. Welcome to Real Estate 360. This is your man Miles. And listen, we are on multiple platforms today. We are all the good stuff. If you're watching on Instagram, I can't really share all the stuff that I want to share with you. But if you are on Instagram, go on over to YouTube. It's the Jason O. Miles Real Estate Network, and you'll be able to see everything there, right? So today, everybody, we're going to go over, like intimately go over land trusts and why they are so important for you as a real estate investor. You don't even need to be a real estate investor. Why is it so important for you to utilize this, or at least understand this strategy, even if it's just you, just your house, just your business, just your car, just your family? Why is this so important? It's important because you need to understand about asset protection, how you can cover yourself, and all the things that you need to have in there, and why they're there, right? Because the things that they teach you, owning your house and buying all this other real estate and you own it, there's a reason that companies own things in the name of companies and trust. And we're going to go over that today. And again, if you're watching this on Instagram, make sure you go over to YouTube, and that is the Jason O. Miles Real Estate Network. The Jason O. Miles Real Estate Network, okay? So let's get into it. Let's not waste much time. You're going to want to write some notes, and make sure you ask your questions in the comments as we do this. It's really important that you do that. If there's something that you're missing, make sure that you write it in the comments, all right? So get something to write with, open up your notes, pull out your tablet, whatever it is you got to do, because you're going to want to know how to make this happen. And FYI, if you go into the description, I'm going to do this for all of September. So if you go into the description, I'm giving you this entire trust package at like a third of what it actually costs, maybe a quarter of what it actually costs. So you can pick that up right now. Hit the link in the description so you can kind of go along with me. I'm also giving you the subject to document package as a bonus. I want you guys to win. So get yourself situated and let's go. All righty. All right, okay, the Jason O. Miles Real Estate Network, if you're watching on Instagram. And the link, no matter where you're watching this, inside the description of this video, if you're on LinkedIn, if you're on, of course, YouTube, if you're on Twitter or X, whatever they're calling it now, and somewhere else, where am I at? Facebook, in the description to this video is the link to take advantage of the sale that I'm giving everybody on on the trust package, the trust documents. You're going to need these. All right. And as I'm going, if you're going to be pig-headed and you're watching this on Instagram, you're not going to see these documents, and you're not going to see all the stuff that is tagged in as to what you can do and can't do and why. So go over to YouTube, the Jason O. Miles Real Estate Network, and here we go. And again, if you're watching, ask your questions as we're going through this. So first and foremost, where's my pen? Here it is. Where's my pen? First and foremost, what is a trust? What is a land trust? Well, a land trust it's a document that separates you, right, the owner, from the parcel of land or the business or the whatever, any tangible asset. And there's all kind of trusts, but today we're going to focus on the land trust. So you as real estate investors know exactly how to implement this in your business, because look, you shouldn't have it in your name. You shouldn't own anything in your name. You shouldn't have it in just your business name either. I mean, I know that's what they teach you, but we're talking, investments on another level, asset protection on another level. And land trusts are really just kind of the beginning or the entry point, if you will, into trust, because there's a ton of different types of trusts. There's land trust, there's revocable, there's irrevocable trust, there's, what do they call them? the trusts that just go on and on and on and on. They're designed for a long time. Hey, Aaron Ward, I see you here, brother. I see you here. Welcome, welcome. So they're designed to last multi-generations, right? So when you think of something like that, you want to think of the Rockefellers, for instance. The reason that the Rockefellers are doing so well, or the family, I should say, is doing so well is because Big Daddy Rockefeller set it up many, 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 many moons ago to make sure that his family would be taken care of from generation to generation. That's what he did. That's what he did for his family. So you should think about these kind of things as we move forward. So what is a trust? What is a land trust in particular? All right, a land trust, you'll see it right here. I got you pinned right here, right? Oh, we don't want that one. Go here. I got you pinned right here. This is what it is right there. It's a separate legal title from true beneficiary ownership. So how does that look? What do you mean, Mr. Miles? Mr. Miles, what do you mean when you say stuff like this? I don't quite get it. So here it is. Think of like a triangle. Let me see if I can put this here. So think of like a triangle, right? There is a grantor. Excuse my language. There's a beneficiary. Okay, and there is a trustee. Okay. So when you're going back and forth into things like this and you're like, okay, well, how does this work for me? We're going to go over that, right? We're going to absolutely talk intimately about how this benefits you, how these land trusts benefit you, and what that, what does that triangle mean? Grantor, trustee, beneficiary. How does this all work for me? Okay. Now, we use this as a tool in real estate investment in terms of how we take over title. It's also something, again, that's very, very useful for asset protection. People use it all the time. And because of a beautiful law that was passed in the early 1980s, I believe it was in 1982, called the Garn-Saint-Germain Act, we can now transfer property without paying all these taxes, like the transfer tax or, whatever the case. We used to use this tool before the financial crash when there were seasoning laws that were put in place in various areas around the country. I was in Atlanta, still am, but I was primarily investing in Atlanta at that time. And if you bought a property, you had to do significant repairs to it if you wanted to sell it within a 90-day period, or you had to wait 90 days. These trusts throw that all out. Here's how that goes, right? Oh, let me say this. It also will stop the due on sale clause, or it will not necessarily just stop it, but it will put it in a situation where you're legally transferring things in a certain kind of way. And I'll just go over that really quickly with you. So a land trust is something that separates whoever's on legal title to the beneficiary ownership. And that's the structure of it, okay? Let me go down here a little bit. And why you want to set these land trusts up, you want to set them up for these reasons here. And then I'm going to go right into the document, and I'll go over key points as we go through this. So it's right here, right? This is where you want to look. You want to set these up for privacy. You don't necessarily want people looking into what you own, right? Let's say for a moment that you are in a situation where you've got 20 houses and there's a slip and fall situation. Somebody slips and falls and they go get a lawyer and they look it up. They're looking you up and they see that you own 20 properties. Well, now you're pretty likely to get a lawsuit. They're going to sue you because they say, okay, here's a rich guy. Let's go get what they can get. Adversely, if this property was just was just one property and one trust and that was it, maybe they sue you, maybe they don't. Maybe they sue you, maybe they don't. Any attorney is going to weigh in and say, okay, is this really worth my time? Yay or nay? I don't know, right? So, but it's less likely that you're going to get sued if it's just that one property. It's just less likely. And again, if you have questions about this, please, by all means, put it in the comments. And if you're watching on Instagram, go over to YouTube and go to the Jason O. Miles Real Estate Network and watch there. Okay, watch and comment there, please. That would be great. All right. Okay, so as we move forward now, another thing is ease of transferability, right? What does that mean, ease of transferability? Ease of transferability means that I do a lot of subject to real estate. So I'll take over a property subject to the existing loans. I put them into a trust, right? If I want to sell that house, I don't need to sell the house. I could sell the trust. So the ownership of the trust, the trustee will change, the beneficiary interest will change upon the transfer of said trust to this new person. We don't have to go through another closing per se and spend all that time and money. We don't necessarily have to do that. Title policies in place, insurance is in place. They'll just make changes to those existing policies, or maybe just get a new policy altogether. So you can sell your real estate, you can sell your business, you can sell your cars. You can do all of that if it's in a trust by just selling the trust, okay? Another great reason to have this, a trust set up, is to not necessarily 100% avoid, but for the most part, you're going to avoid a lot of judgments like I was just talking about. So the privacy and the no judgment, the no personal judgment piece is a pretty big deal, right? So how does that work, Miles? I don't understand. You know what? I just have to have a trust and put my stuff in there and they can't sue me? Well, you have to have another layer of protection associated with that trust, and that's by having an LLC. And it really doesn't matter where you have the LLC, but I can tell you as a side note that the Wyoming LLCs are adding an additional level of anonymity, right? It costs a little bit more. It doesn't really matter. But if you're looking for anonymity, you want to get your LLC set up there, set up in Wyoming. So you can have an attorney do it. You can go online to the Secretary of State of Wyoming, find out what you need to fill out the documentation, pay whatever the registration fees are, and go from there. You know, set up your LLC. If you're a single member LLC, it's a lot easier to do it that way because you're not going to have, you're not going to have a whole bunch of stuff in your operating agreement because it's just you, right? You will, allude over to the trust because everything would stay in the trust. And whoever is your beneficiary will then take over the LLC, will take over the trust, will do all of those great things. And no one is the wiser. Why? Because you don't file these documents. You're only filing a deed. And the only thing on the deed is the name of the trustee. And that's it. And if that trustee is an LLC, well, then they got to go digging into that. And then if by chance you are forced to show your trust documentation, you can go ahead and show them that trust documentation because you're just the trustee. And it says on there that you get paid however much per year. I put on mine $10. Some people put $200. It depends if you're using someone else, because there are companies or other people that you could hire to be your trustee. You got to trust them though, right? You've got to trust them. But there are people that you can hire to do that. But there's documents. If you have someone else doing it on the filed one, we're going to go over a little bit of that here today. So, and again, as I mentioned before, the fourth reason, if you're investing in real estate, especially in the subject to space, is the due on sale clause. Why? The reason why is when you initially do these documents, as I'm going to show you here in just a second, in the declaration of trust, it's the person that owns it, right? The person that owns it is, or whose name is on title. Let me say it that way. The person whose name is on title today, okay, is going to grant the beneficiary or the third party, another entity, another person, another company, like an LLC, right? They're going to grant them, name them as trustee. All right, they'll remain the beneficiary. So the trustee will come in, you form the document. If it's, if you're buying a property at 123 Main Street, you might call it 123 Trust or 123 Main Trust, whatever you want to call it that you can remember for that particular property. And you can have, well, we'll get into that in a second, but you want to do that. And then that's it right there. They're the beneficiary interest. That goes back to the Garn-St. Germain Act. That person is transferring this asset into a trust for asset protection, and they're still the beneficiary. Or they could name a family trust as the beneficiary. Same rule would then apply. All right. And so the due on sale clause won't be going from that. Let's see. We've got a question here. Let's see. Let me pop it up. AC Studio says, hi, Jason. Ricky here. What's up, Ricky? For selling, transferring a trust with a property on it, do we need a lawyer or just to notarize it? Good question. You can just notarize it. It depends on the investor that you're working with, because it's really going to be their call, right? If they feel comfortable enough with you, maybe they've done a title search. I always recommend it, as you know. And by the way, I want to say congratulations to Ricky. Ricky just got his first deal. I also want to say congratulations to Selena. We've got Steve that's got a paycheck that's come in. So from our challenge, well, Ricky wasn't technically a part of the challenge. He came in at the end. But from our challenge, we have currently had 2 closings and 3 closings. One just hasn't funded. They did the documents. It'll fund tomorrow. And then we've got, because there were 11 properties under contract. 3 of them have closed. I know that 2 of them or 3 of them, well, either way it goes, by the end of the week, half of those are going to be closed from a 30-day challenge from all new people. Excuse me for a second. Good water. Ooh, that's good. All right. So, again, real quick, thank you for asking the questions. Keep asking questions, you guys, if you have questions. I want to make sure that I'm getting them answered for you. We're going to jump into the document here. And again, if you're watching on Instagram, go to YouTube, go to the Jason O. Miles Real Estate Network, and let's make that happen, okay? All right. So let's get into the first document here. All right. So this is the Declaration of Trust. Okay, it's a land trust agreement. Let me just pull it up so I can see it a little bit better. I hope you guys can see that good. Okay. All right. So you're going to, as you fill this out, you know, you'll see here where you have, move me out of the way there. You know, it's going to be whatever state you're in. Now, there's a couple states where you're going to have to do something different. Illinois is going to be a little bit different. It's really, really very different, very similar to this. It's not that different at all. So if you're in Illinois and you're asking, well, I know we've got things that we got to do there, this will still work. Just close with an attorney so they can get it structured for you properly. If you're in Arizona, there are some disclosures that you have to make in terms of who the beneficiary is, who the trustee is, things like that. You've got to disclose all of this information, but I'll still show you how you can create that level of anonymity, even if you're not using a Wyoming LLC. All right. All right. So you're going to fill it out for whatever state and county that you're in. And you'll have to excuse me here. I don't have my little colored cursor. So I don't know if you can see me moving that around over there, but you'll fill that out. Let's see, Aaron Ward, are you, I'll get to your question in just a second, Aaron. All right, so you're going to fill that out whatever day, month, year that you did it, known as, and this is where you're going to name the trust, 123 Maine, or just 123 land trust, whatever you want to call it, 123 Maine, a land trust, is to certify that blank, whoever you're going to have be the trustee. And I recommend that trustee be not an individual. And if it is an individual that does not have your last name, you do not have, a relationship. Okay. So that is going to be important, again, for another level of anonymity. You want to have anonymity with trust. It's not it's asset protection, yes, but there are certain things that you're not going to be able to avoid. Okay. Like paying taxes, because even if you're taking over houses subject to, which is, again, what I would tell people to do. Some people close them in LLCs. I tell people to do it this way because you want the anonymity, excuse me. All right. I lost my train of thought about what I was saying there, but I'll get back to it. But you want to make sure that it's not an individual that's personally connected to you, not like blood, or, so make sure it's an LLC. Make sure it's an LLC. That's the way that I would tell you to go about it. Have your LLC do that, or an LLC, and we'll get to there. I'll get to that. As duly authorized to accept and execute trusts within the state of whatever state you're in, is about to make title of the following described real estate in blank county and whatever the city is, or state, excuse me. And then you just fill those things in, and it just goes on to say that subject to the power of direction hereinafter provide. I mean, this is a bunch of legal mumbo jumbo, so I don't want to bore you with a bunch of it. But whoever the beneficiary interest initially is going to go right there. Oops, I went way too far with that one. Sorry. All right, so whoever the beneficiary is going to go right there. Why is this not working? I'm just trying to scroll down and it's not working with me. Here we go. There we go. So if you're doing subject to and you're taking this over from an individual, you're going to have that person put their name right there. They're the ones that are going to be the beneficiary. They're the ones that are granting you the ability to do that. And here, I just went past it. Here's where you're going to name who the successor of the trustee is. And if it's an LLC, as you want it to be, it's going to be however your LLC is structured. So if you're a single member LLC and you're protecting your assets, let's say, you're going to have in your operating agreement or in your will or whatever you've put together, who's going to take over for you in said entity. They would be the ones to fulfill the trustee obligations to the trust that you're set up with right here, okay? And then it's just a bunch of legal stuff that explains who's doing what and how. Here's where I have at the bottom here, at line 16, where it says how much the trust pays the trustee. And it doesn't have to be a bunch of money. There always has to be some consideration. You don't have to sit there and be the greedy person. And I would tell you to not do that, right? Don't be the person that says, oh, I'm going to have the trust pay me, $100,000 a year. Don't do that. Don't do that, because now you're putting yourself in a taxable situation, which is what you're trying to avoid. All right. You're trying to avoid that. So putting yourself in that situation isn't going to help you at all. It's actually going to hurt you. So don't do that. Don't take too much money. Don't worry about anything. I'm sharing with you here how to own control everything and own nothing. Okay. The only people that are going to know that you're doing this are people that you share it with and the IRS. Why the IRS, you say? Because you're going to do taxes and you're going to declare the money that you've got coming in. And when you're declaring that money, you're going to declare depreciation. They're going to see that a big piece of your income that's going out, your expenditures, are mortgage payments. And then they're going to look at you and say, but you don't own any real estate. Then you're going to have to show your trust agreements to them, right? And you say, okay, we own this. Here's this document that says we own this and this is why. And then you're fine. It's not an issue. But if you ever called on it, you have to know what it is you're going to say and how you're going to handle this. Again, if you are watching, because I can see that I'm running this feed, guys, on Instagram because I want them to come over to YouTube, to the Jason O. Miles Real Estate Network, because I got a lot of people that ask questions there, and I want them to be able to get this information as well, okay? So let's go here to Aaron. Aaron says, are you easily able to add or remove properties if they are already in your trust, i.e. loans, et cetera? Yeah. So you're just going to transfer, Aaron, the property from, you're going to fill these documents are the documents that you're going to fill out. And there's a lot more, but I'm going to go over that with you. You're going to fill out these documents. These documents stay with you. Okay. There is a warranty deed that you will fill out. That warranty deed is what gets filed, which is going to be, assuming that it's you, transferring the property from Aaron Ward to AWLLC, right? Or whatever you call it. Or not the LLC, but AW Trust, okay? Whatever you call it. It'll go to the trust. And then you'll have one of your LLCs be the the trustee or the beneficiary, or the trustee and potentially the beneficiary, depending on what you want to do. We'll go into that in a second. Dave sent a request to be in your video. Dave Johnson. Hold on, Dave. I can put you in on I can put you in on Instagram. Okay, so we'll do that. Okay. So Dave is in. All right, so Dave, if you, Mr. Dave Johnson, if you want to take full advantage of this, go to YouTube. Go to the Jason O. Miles Real Estate Network on YouTube. All right. Okay, so back to Aaron. So you got your property, you get your documents, you fill out all the documents, you get your warranty deed, you fill out your warranty deed. You literally just file it with the county, city that you're in. And that filing fee for that is probably going to be, $20, $30. It's just going to be different from state to state, county to county, right? But it's nominal compared to having to pay transfer taxes, all right? And if there is a loan in place, this would be the second part of your question, no problem at all. You're going to not say anything to the lender, but you are going to say something to the insurance company. You're going to let the lender know that you've given the power of attorney, the limited power of attorney, for someone to speak on your behalf, which we'll get into in a moment, and that person will speak on your behalf in all matters related to that particular real estate. With the insurance, you may already have a non-owner occupied policy in place if these are rental properties, which is great. All you're doing is letting them know that, hey, I'm taking this person off. Well, I'm leaving this person on. If you are the person that got the loan, Aaron, you want to keep yourself on there as a loss payee. You want to make sure that the mortgage company is on there as a loss payee. You want to put your LLC on there as a loss payee. You also want to put your trust in there, the name of the trust in there as a loss payee, right? Some people will have a management company in place, all this other stuff, which is fine. There's nothing wrong with that, right? It's just a lot of payees. You just have to let the insurance company know. Then you're straight. You're good to go. It's not going to affect you negatively from that moment on. You just have to do that part. If you're doing that, you're good. You're good. If the house burns down, the money will be given to the trust. And then the trust, whoever the trustee is for the trust will go ahead and deposit that into their bank account on behalf of the trust. You can even go so far as to, with the LLC, get a DBA for the name of the trust and add it to all of the documents. Follow me? Cool. Thank you for the question. Let's see. Big Mike has a question. I can pull title without speaking with an attorney company or a title company, excuse me. Yeah, you can. I mean, there's title companies that you can hire, right? That you don't have to go through the attorney, but you want to make sure that it's certified. This is just my position. You can get somebody to pull a title for you probably for a couple $100, maybe $150. But going to the attorney, they're going to charge you, attorney, a title company, probably 4 times that, 3, 4, 5 maybe times that. Okay, that's how part of the way that they make their money. So you want to be, I always err on the side of caution. I always use attorneys. Why do I always use attorneys? I use attorneys or title companies, depending on the state that you're in, because I can get a title insurance policy. But if it's your property, you already have the policy. You already got it in place. But I can get a brand new title insurance policy, which is going to cover me from any creditors that might be going after the person that had the property prior. If there is a problem with legal documentation, since it all went through that office, they're going to be the ones to clean it up, because it's a strike against their E&O insurance, their errors and omissions policy that they have to have. And they don't want to do any of that, so they do everything by the book. It just costs more money. It just costs more money. That's it, right? So if you went and looked for someone to pull your title, just know that they'll tell you what's on there right now, but it's not going to, because you're not getting a title insurance policy, there's no protection for you in the event that something comes up later. if that makes sense. Now, you might say to me, Miles, well, hey, listen, aren't you transferring this into the name of someone else? Didn't you say that in the beginning? And I would say, yeah, you are 1,000% correct. You are transferring it into the name of another entity, which is the trust, right? And this person's name is no longer, the individual's name is no longer on the title. So if they did a title search for that property, they would not see your name. They would see the name of the trust. They wouldn't even see the name of the beneficiary or the name of the name of the beneficiary. They're not going to see any of that. They're just going to see the trustee's name. That's it. Okay, that's all they're going to see. And I'll go over just a few. Let me just get through this document so I can get back to the Q's. I want to answer the Q's. All right. And then they'll just, you sign, you get it notarized. You get a legal description for the property, which you can pull that parcel description offline. You add it to this, and you keep it in your file cabinet. You're not filing this with any state regulatory situation, none of that. You keep this. This is the beauty of it. No one's going to know. No one's going to know. No one's going to know. Okay? Nobody. All right. So let's get back over here. I want to go into some of these questions here. So who should the beneficiary be? I kind of already went through that. We know that the beneficiary should be a trust, an LLC. It should, when you're going to do this, Doc, I'm going to explain to you, it's going to be the owner of the property, the individual, right? They're going to be the beneficiary on this, okay? You're going to have another document, which is them assigning their beneficiary interest over to the entity that you want. But in the event that you have to show your trust documents, and let me be clear about this, in the event that you have to show your trust documents, it better show that person who's supposed to be on that loan or on that deed, their name is the beneficiary interest, or a family trust, a trust, it could be another trust that they are a beneficiary of. Does that make sense? Or their family, okay? If you ever have to show that document, that's the document that's going to save you, okay? The assignment of beneficiary interest, which we'll go over next, that assignment is them granting their beneficiary interest over to your entity. And you keep that also in the file until it's time to close it, like sell it, refinance it, whatever you're going to do. Until it's time for that to occur, you just have that sitting away. Again, no one's going to know who owns the property. No one's going to know unless they do a super, super deep search. And we'll talk about how you protect yourself from a lot of that as well. You minimize yourself from that. As long as you're not doing any criminal activity, you're good to go, right? So getting back over here into some of the good questions that we had. So again, it's you're going to create a land trust. You get a trustee, and then the beneficiary, which would be you or the person you got it from, and then they're transferring it into an LLC, right? And that's the assignment of beneficiary interest. And we'll go over that in here a second. Now, here's some common mistakes I wanted to share with you as well. A lot of people really mess up when it comes to this kind of stuff. And, I want to make sure that you get really good at what it is you need to do with this. Hold on one moment. I got a couple questions I really want to get to here. AC Studios, Ricky says those $10 need to be paid and reported somewhere. Yeah, so whoever the trustee is that you've named on there, if it's $10 or $200, that is going to be an expense to the trust. Okay? That's an expense to the trust, just like any other business. And in this case, the expense to the trust rolls over to the expense of the LLC. So it's just an expense line. So I hope I was able to answer that good for you there, kind sir. I've got a couple questions. This is a really long one here. All right. So in a sub-2 deal, computer's a little bit away from me here. In a sub-2 deal, do we need to inform the beneficiary or seller to know that the property or trust was transferred? The answer would be no. Do we need to just report it to the insurance company? The answer to that would be yes. So you don't need to inform that person at all. Again, one of the reasons, so we have someone else that joined here on Instagram. If you're watching on Instagram, please, by all means, go over to YouTube. It's the Jason O. Miles Real Estate Network on YouTube, and you can see everything that I'm doing there. You can see the documents, you can see the questions, you can see the comments, you can see everything. So go on over there, please. All right. So yeah, they don't need to be informed. So when you've got your sub-2 deal, one of the things that I recommend, as we spoke a little bit about, Ricky, which we'll be doing this week, is putting in place a servicing company. Why have a servicing company? Having a servicing company in place is going to add a lot of credibility to what you're doing, especially when you're talking to people that you're trying to build rapport from when you're doing sub-2 deals. It also takes a lot of reporting responsibility off of you. Meaning, well, this person, 2 years from now, they signed a deal with you on the sub-2 deal. 2 years from now, they want to go get another house. Their mortgage broker tells them they can't buy a house because they've got this one on there already, and it's destroying their debt-to-income ratio, which is ruining their chances from getting a loan. Well, that mortgage broker doesn't know, because they're going to tell them, hey, you know, I did a sub-2 deal. It's rented out, whatever. It's being paid for. They don't know. So what he's going to do is call the servicing company, request what do you call it? A report. They're going to send him a report, and he's going to send that over to the broker, who's going to give it to the underwriter, who's going to give them 75% of whatever that mortgage is. They're going to take that off of their debt-to-income ratio, which will more than likely put them back in the running for a house, okay? So mortgage brokers, a lot of them don't know this. And for those of you that have been working with me, when we're talking to real estate agents, they don't know these things. They're getting an education from us, right? Most of them don't even pay attention. Most of them don't even pay attention, so we just keep moving. So I hope I was able to answer your question there, sir. I hope I was able to answer your question there. And one more question, I'm going to jump right back into the documents. Boss, hey, May. Boss, hope you can make a live regarding novations. Yes, I will. Novations are, let me get a little sip of water behind that one. It's such good water. Yeah, I went to Wet Willie's. I got myself one of these Wet Willie mugs to go. And I love it. I love it. It keeps everything cold for a long time. No, it's not Wet Willie's in there right now. It's just water, not fire water. All right. Okay. So back into this common mistakes, and then we'll go back to questions that come in, please. All right. So going back to the common mistakes, the number one, and these aren't in any real order. These are just things that I have seen people do, right, and mess up on. All right. Never serve as your own trustee. Why? Because if you are both the trustee and the beneficiary, the title can be merged back into your name as the grantor. And that kind of defeats the purpose of doing that. So you always want to make sure that you are not the trustee if it's your house, but the beneficiary. All right? You put a third party in there as a beneficiary. Period. Now, who do I use for my stuff? I use my attorneys. So sometime back, oh man, this had to be about 8 years ago, the attorney that I was using retired. So people were like, oh my God, what are we going to do? The people that were also using him, that we brought over there. It's a very simple thing. You just assign the trustee, the trusteeship as the grantor. You can do that. The trustee can actually do it, can name his successor. The trustee can name their successor. It's not a big deal. It's literally one more piece of paper, and you're just naming the successor, and that's that. And that's that. Okay? So simple situation. But don't do it. Don't put yourself in that situation, right? Because there's a bunch of little catches that lenders can catch you on if you allow yourself to be caught, all right? Number 2, Do not use your home address on tax statements. Why? Trusts are for anonymity. I can't say it enough. Trusts are for anonymity. Anonymity means no one knows it's you. You don't want them to know it's you, okay? So do not use your home address for tax statements as it relates to your trust, okay? This completely defeats the purpose, completely defeats the purpose. Now, what can you use? If you have a business address, use that. If you have a P.O. box, use that. But do not use your home address. Don't do it, okay? There's too many different ways that can come back to bite you in the buttocks later on. Number 3, failure to assign beneficiary interest. Why is that important? Why would that be? Because if the trust is sued, you will be liable. Boom. Who wants to be liable for a lawsuit? Not me, not you. So you have to transfer that into another entity. Even if you're using this for asset protection and it's just you and your family, you're going to name someone else as the beneficiary. We only put it on the initial documents when we're doing sub-2 deals because we need it to be that way in the event that a lender needs to see it. In some cases, you'll have attorneys tell you things like, well, you can't put them on there because it's not an arm's length transaction. Well, it's not supposed to be an arm's length transaction. Okay? It's not supposed to be. And they'll say they can't write the policy if it is. But there's a lot of different ways for you to circumvent that. That is literally just one, maybe 3 sheets of paper. All right? But 2 signatures though. And that's that. You just have to know what to do. It's not a problem that is insurmountable. It's something that you can have handled in a couple of hours, depending on where the people are that need to sign. All right? Number 4, informing your lender. As I said before, do not tell them. Why? Because even though the lender can't accelerate the note, because, the due on sale clause, they can't just accelerate the note because of the Garment-St. Germain Act that I talked to you about. It is possible that they can assess a transfer fee, though. So there's not a ton of lenders that are doing this, but I would imagine that there will be more and more that are going to add this in to their loan documents. But the ones that are currently doing it, they're charging up to a 1% transfer fee. So the ones that I've seen, and I've only seen a couple. Well, one of them was a 0.5%, and one was a full percentage point. And that's of whatever the loan balance is. So if you're doing a sub-2 and you're transferring, or you're just transferring a property because you want to protect yourself, if the lender wrote it into their agreement that they can charge a transfer fee, if you owe $200,000 and you at the time of transfer, they see that transfer on that time, they know what it is, they can charge you 1%, $2,000. That's what they're going to charge you, or up to 1%. Let me say it that way. All right. So you want to be cautious of stuff like that because when I say cautious in this case, you just want to know. You want to know. And reading those documents is going to help you know. Talking to the lender is going to help you know. You can avoid it, and the only thing they can do is send you a bill. So even if you don't read it and you don't know, all they can do is send you a bill. And that's the worst that's going to happen. All right. Number 5, referring to the trust as a land trust. Why? Call it a grantor trust. It's accepted in all 50 states. Now, if you're doing a ton of deals, then yeah, I would tell you to just call it a grantor trust instead of a land trust. And those have everything to do with the 2 states that I just mentioned, okay? It's really just those 2 states. I am currently unaware of any bills or anything in any municipality that have to do with asset protection laws being changed in this manner, okay? So unless you're doing a ton of them and you're working in some of those places, utilizing it as a land trust or calling it a land trust is just fine. But if you want to, err on the side of caution, you can call it a grantor trust because, again, land trust, grantor trust are accepted in all 50 states. It's just what you're going to call it, and there's only 2 states where it'll be structured a little bit different. That's just, again, let me say, I am not a lawyer. I have just spent, I started doing trust in 2004. So for 19 years, I've been chasing around attorneys, learning, being out here in these streets, making deals, making things happen from state to state. From state to state. I'm not talking to you about just what I do here in Georgia. We do it here. We do it in Alabama. We do it in Texas. We do it in Arizona. We do it in California. We do it in Florida. We do it in Carolina. I mean, we do it everywhere. So it's imperative that, you can hear me, and I'm appreciating everybody that's here listening and asking questions right now. But I got to tell you, the information that I have is great. It's usable. We're using it all the time, but go to an attorney. Talk to your attorneys. They're going to charge you up the wazoo, but that's okay. That's okay. I can't tell you how many thousands and thousands and thousands of dollars I've spent on these contracts, the whole contract package, that over the years, modifying them, bringing them up to date every so often. When the law changes, we're changing them, or if we want to do something different, or if we've recognized some kind of acknowledgement we need to add or subtract, we make it happen 100% of the time. We have to deal with attorneys to do it because we want the legal jargon to be there the way it should be, right? Because all those if, ands, and buts and twos matter if they're not in the right place. I want to make sure they're in the right place. And I want to have a level of protection. If somebody makes a mistake, it's going to be them, right? So I don't even know how much money we've spent on these contracts over the year. I have no idea anymore. It's definitely five figures, though. Definitely five figures. All right, so we have a question here. Get to it. Star, what's going on? Great information. Glad I've subscribed. Don't forget to subscribe and like, people. Please do. Please do. And thanks for the PSA. I appreciate the PSA, Star. I need that. Thank you very much. Okay, we've got another question here. This question is by Ricky. Great info. Love the summary of common mistakes. In the last deal we did, why did the title company ask for the beneficiary and trustee to be the same? Yeah, I just went over that, and that's a really good thing. So this was a deal in Texas, right? So this attorney, and I got to tell you, I have absolutely no idea why she would want it this way, because it defeats the purpose. They said it was not an arm's length transaction, and it is an arm's length transaction. I even cited the law to her, and she was like, well, I do a ton of these in the state. We work with a lot of investors, blah, 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 which they do. They do. This is the first time I've dealt with this attorney. It's one of those companies that have, a lot of offices around the state of Texas. I think they're just in Texas, but there's a ton of them. They're all over Texas. And she just felt, or believed would be a better way to say this, that it wasn't an arm's length transaction. Of course, she knew we were buying them. She knew why. She knew what we were doing. She knew that we were buying that house, or that you were buying the house. She knew that we're doing this to avoid the due on sale clause, which is why we just did two trusts. We did the one they wanted, which gave us the title policy, and then we did the one we know that we need to have in the event that we need to show documentation to the attorney. The only thing I was concerned about is to make sure, which was fine, that the warranty deed had the trust and the trustee name on it. That's the only thing I was wanting to make sure of. And as long as that's in place, then we're safe. We're 100% safe. And we wanted to make sure our trust was signed. We had two trusts signed, one the way the lawyer wanted and the one the way the lender's going to want it. And that's the one that we're going to use, the one the lender wants, because that's what's most important, okay? All right, let me go over here. Let's get on now. We've seen that trust document now, which has the beneficiary interest as the person that you got the property from, right? But we don't necessarily want that, because we're not going to be able to sell it if that's the case. So, we go here. Let me go up here. Let me make this a little smaller, see it all. All right. So here is the assignment of the deed of trust. They're assigning this deed from themselves as the beneficiary over to you, okay? So as you can see, you're just going to, this is what it says: the undersigned grants and assigns and transfers to whoever the trustee is all beneficiary interest under the certain deed of trust dated, executed by, and then you put the trustor, which would be the person that you got it from, to the trustee, whoever that person is, or whatever which is going to be here, and recorded an instrument number on blah, blah, blah. These are numbers and pages and things you get after you file it. You get that from the county, okay? So, and then you just attach it and you go from there. You'll put in the county and the state a couple different times there, the district that it's in, and they sign it, date it, notarize it. And now you put that in your file cabinet, and you don't worry about it anymore until it's time for you to refinance or sell. Until it is time for you to refinance or sell. That's when you're going to pull those documents out 100% of the time. So you want to make sure that you're safe in that. You want to be protected in that 100% of the way, and that's how you do it. Now, another question that people ask a lot is, how many properties should I have in one land trust? That's easy. One. The real question is, how many land trusts can be in one LLC? Because again, if one goes bad, it all goes bad, right? So if you have, let's say you've got 10 properties in one trust, you call it the 10 properties of Georgia Trust, and you put them all in there, but there was, and I always use the slip and fall thing because that's the most common thing, but somebody slips and fall at the first one, they're going to want to sue, and then when they go to the attorney's going to say, okay, well, this trust has 10 properties in it. They've got some equity. Let's go. This is an investor. Let's go make it happen. They know, depending on how long you had the property, you've got at least 20% equity in it. Yeah, you could have as much as 50% equity in it. Enforcing a sale is how they get paid. Unfortunately, that's how it works, but they're going to see that. So if there are 10 trusts or 10 properties in one trust, they're going to see that. Now, if you take one trust and you make an LLC the beneficiary of 10 trusts, right? 10 individual trusts, each one has one property in it, and then the trustee or the beneficiary, or the LLC is the beneficiary, of all 10. Could the LLC be, or not the beneficiary, but the trustee of all 10? Could they be sued? Yeah, but once they see this document, they're like, okay, well, they don't got anything to pay. They owe $10. They get $10. There's nothing we can get out of them, right? But I limit it. I limit to X number of dollars. It depends on where you're buying. So, like here, I'll do, right now we're at $1.5 million per LLC, right? If I'm buying in California, it's going to be another number. But we get umbrella policies to cover everything inside there. All right, does that make sense? So we will have one LLC that manages assets from other trusts up to $1.5 million. Okay. For the kind of things that we buy here in Georgia, that's 5 or 6 houses. For the kind of things that we might get in Texas, kind of the same. It could be less. It just depends, right? Depends if we're getting $500,000, $400,000 or $500,000 houses. Obviously, that's going to be a little bit different, and we want to make sure that we're covered. We want to make sure we're covered, and then we just start another LLC for another $1.5 million, and another LLC for another $1.5 million. And you might say to yourself, "Well, Miles, that doesn't make any sense. Why? You got to do accounting on these things every year, and you got to pay taxes on these things and do taxes on it." Yeah, you're right. But guess what? I don't do it. I pay somebody to do it that does that. And then we just keep the books. Well, more importantly, they keep the books. They tell us what kind of software we need, and we align, and they can keep, monthly and quarterly records. We don't have to do that. We don't have to pay attention to that. We get a breakdown of what we're spending our money on a monthly or quarterly basis, depending on what we want to do. But that's up to how you choose to do these things, right? And again, land trusts are legal in all 50 states. There's no place that says you can't do this. No place. So if you're wanting to get into this, that's how you do it. But there's one more document I want to share. We went over the trust, we went over the assignment, and the last document. And again, these documents are in for this month anyway. You can go into the description here. In the description, there's a link. I'm giving you half. Well, it's actually about 2/3 off of these documents because there's some more documents that you're going to need that are going to come from the attorney in your state, which is why I made this happen. But this is going to be enough for you, for real, for real. This is everything you need with the exception of the warranty deed and the attorney. All right? And you're going to need these things. If you're going to use them, I'm telling you, they are infinitely important in your life and business. If you want to protect your assets, you're going to need them. Okay? You're going to need them. Protect your assets by utilizing these things. And especially if you're doing sub-2 deals. If you're doing sub-2 deals, I mean, really, especially anything. I mean, I know that, again, as I stated earlier in this, a lot of investors are just, putting everything in their LLC name. I'm telling you, don't do that. Do not do that. Do not do that. I mean, it seems like you're protected, but when that LLC starts doing more and more and more and more, I'm watching people right now that are going through it because they're trying to be slick. They're trying to be slick and transfer things around, and it winds up right back on them. And they're going to be liable for all of the assets they had because they transferred them improperly. Okay, so now you got your land trust. Now you got the assignment of the beneficiary interest in place, and now you have to get this taken care of. This is the a limited power of attorney for property, mortgage, and insurance. All right? This is the document that's going to allow you to talk to the bank, talk to the insurance companies, talk to everybody you need to talk to associated with that piece of property. And so you get it on every single one. All right? Let me go up here. Got to try to make it a little larger so you can see it. There we go. All right. I, the undersigned principal, whoever the person's name that's on the loan, resident of the state of whatever, hereby appoints whoever as a representative, and that is going to be the name of the trustee. And then you put the address down there. The address will go again right here. To perform all actions in the name and place of principal related to the real property located at 123 Main Street. All that great stuff there. And then the principal will sign right there. Your witness will sign right there. We'll put their name and sign, and then you will then get it notarized, and that's it. So this is the assignment of the deed of trust. So that's it. These are the documents that you're going to need to be successful as a real estate investor, to be successful at protecting your assets. And believe me, it gets a lot deeper. The more assets you get, the more cash you start to make, it really, really gets a lot deeper, right? So, but in the meantime, this is where you need to be. And this isn't really, it's not like it's even the starting point, right? The starting point was when you first got up and said, I'm going to do real estate, and you were signing all the contracts in your name. Then you got wise, or you heard somebody tell you something real good, and they told you, you need to have an LLC. I can't work with you if you're not using an LLC. So then you go get an LLC, and now you're doing everything in the name of the LLC, and you get a bank account in that company's name, and you put your phone in there, and you start doing all the things you need to do to build that business, and you feel good about yourself, and you're doing business in the name of that business. Hey, that's great. I'm not going to tell you that's not good, but I'm telling you the next step is the trusts. The LLCs are another level of protection, right? Or one level of protection. The LLCs take it to another place, take a completely different place, right? So just to kind of throw it out there, like if you're getting hard money loans in the state that you're in or wherever you're doing business, let's say you're out of California and you get a Wyoming LLC and you want to do business in Alabama and you're getting a loan to renovate a property, let's say. Well, they're not going to want to use that Wyoming LLC, not the way you want to. They're going to want you to have an Alabama LLC. And then once you have the Alabama LLC, it can be wholly or partly owned by the Wyoming LLC, however you're structured. But you're going to need that Alabama LLC because of where that property is located. And that's going to be in every state if you're getting hard money loans, because they want it to be in that state. And that's cool. That's fine. There's no problem with that. You just have to know that that's what you need to do. So if that's the case, you do that. It's just another level of anonymity. So, but here's what happens. When it's time for you to get a check on that, you're going to give them the Alabama LLC documentation. Then they're going to see that it's not just you, but it's owned by another company. And you're going to have to give them those operating agreements and some other documents that they're going to want, resolutions, things like that. And then they're going to want your information on top of that. And that's okay. It's just more paperwork. And if you've got them sitting in your file cabinet, or most of these documents you're going to already have scanned in a file that you can access like that when you need to send it to an attorney. You don't have to go looking for them. You just have all your LLCs digitized in one place, and then you have all the hard copies, the paper, the wet ink signed documents put to the side somewhere. I would recommend, if you're doing a lot of this, to go ahead and get a nice fire cabinet, like a fire safe, but it's a cabinet for files, because you don't want your documents to go up missing. You don't want them to go up in smoke. But again, that's why it's important for you to have them digitized as well. It's also another reason why I like to use attorneys and title companies, because they've got copies of the documents. So in the event that my wet signed documents, my hard documents were damaged, destroyed, some lenders might not take it coming from me. They're going to want it from the attorney. So if I can go to the attorney and get it okay. So I'm okay with spending the extra few $1,000s that it takes to close these deals with attorneys. I know that a lot of other investors don't do that. They just use mobile notaries, right? If I'm using a mobile notary, it's because the attorney sent that mobile notary, not because I called them, unless they told me to call them. Well, that's it. That's what that is. So I implore you, go into the description, get this package. I'm going to let it run through September. I'm going to be talking about it all month long. I want you to have these documents because they're expensive. When you go to an attorney's going to charge you anywhere from $1,000 to $1,500. And then there's more documents that you're going to need anyway, that some attorney is going to charge you for those, your warranty deeds and all that. But if you're closing with them, fine, no problem. But it's just more money, more money, more money, more money, more money, more money. And you can reuse this. It's not, once you have it, you're not going to say, oh, I've got one and I got to go pay another $1,500 to get another one. No, these are going to be Word files that these are Word files that you can manipulate. And if you're doing sub 2 and you don't have all of the acknowledgments, that's a bonus for this. I'm giving that away. I give that away most of the time anyway, but it's included with this. These documents, people come through doing sub 2. They don't have sub 2 contracts. They don't have the right, they don't ask the right questions to the seller, and they open themselves up for potential litigation. I've been a part of those lawsuits. I've been sued because I didn't know these things. These things are in place. And Ricky, if you're still listening, if you're still there, because I know you've seen these documents. We've gone through them inside and out over the past couple of weeks. And listen, we're asking them everything. We're making sure they acknowledge everything when we're doing sub 2 deals. They're acknowledging that the money that we're putting up is not a loan. They're acknowledging that they understand this is a sub 2 deal. They acknowledge that they're not going to be living in the property. They acknowledge that they're moving out of the property if they haven't already done so. All of that, everything. I mean, and there's 2 pages or a page and a half of just acknowledgments. Just acknowledgments, because I got tired of being sued. I was only sued a few times, but it was what I would call negligence on my behalf. I was still learning. This was years ago when I was first starting out. There are things that are going to be covered in here. There's something called, well, it's not covered in here, but there's something called inference of ownership. And when you're selling it, depending on what your exit strategy is, this is a side note, but I think it's important if you're doing sub 2 deals and you're doing wraps or lease options. If you're selling the property at a higher value than what it is today, it needs to be at a reasonable clip, right? So if you're doing, I don't know, a 3 or a 5 year turn, right, or a deal, you're doing a lease option for 3 years. You don't have a crystal ball, but you could say, well, the house is worth 300 today, but I think, it'll be worth, maybe 330 in 3 years. So you give it a $330,000 sales price that reflects the price when they actually give you the money. Okay. That's fine. But if you take that same $300,000 house and you say, well, we've had a couple good years, back there, 2-3 years back there where, we've got 30-40% gains. I think we could do the same thing there. And then you sell a $300,000 house for $420,000 house 3 years from now, and the person can't get a loan because the house is only worth $330,000, $340,000. If they feel slighted, they'll go get an attorney. And that attorney will be intimately familiar with the term inference of ownership, and you will lose. Whatever they gave you, whatever they paid you, you will have to give that back to them, except for the time they lived in the house. So any down payment or any fees associated with them getting a loan, appraisal fees, doc prep fees, you're going to pay for that. Legal fees, you're going to pay all of that because you got greedy. So don't get greedy. All right. All right. Ricky says, the docs are super comprehensive. Totally suggest everyone get these docs from Jason. Okay, absolutely. Thank you. Thank you, sir. Listen, we had Ricky's done special for Ricky, right? They're special for Ricky, but I'm pretty sure Ricky's here and he's looking at this and, he's looking at these trust docs and he's like, yep, those are the ones. I'm telling you, we go through this stuff. We're talking to our attorneys probably every, I don't know, it depends on what's going on, but at least every 6 months to see if there's something that we need to change. We're constantly changing things in our sales contracts to reflect. Well, thank you, Ricky. No, thank you, kind sir. We're constantly changing our PSA contracts to reflect what's going on in the market at any given time. Because that changes constantly. Market conditions change constantly, but laws don't. Right? They don't change as frequently as, the whims of the market. So it's important that you're being on top of your PSA contract, your purchase and sale agreements, because things that we've got different agreements for when we're buying than we do when we're selling. Why? We want certain protections when we're buying. We want certain protections when we're selling, and they're different. We're protecting ourselves. So our PSA is different for buying and selling. So the PSA, but they're different for buying and selling. Why? I'll just give you a couple things. When we're buying a property, depending on who we're getting it from, we want to make sure, number one, that our earnest money is protected, right? So there's all kind of verbiage in there for, what, if this isn't right, we get our money back. It doesn't matter if due diligence is over. If it's out of our hands, you got to pay us back our money. We ask for the right to market the property as well, which kind of goes into what May was talking about novations, but that's not a novation agreement. But they acknowledge that they're giving us that we're going to be marketing it, and they're signing that paper. It's a initial on the PSA that says these guys are going to market it, and they're going to market and or buy it in one of their entities' names. And then we have a number of our entities named on there. And now we can go ahead and we can't list it on the MLS, but we can put it on Zillow. We can market it all around, social media sites, any platform other than MLS and FMLS, basically, right? You need another type of agreement, which is the novation. And I promise I won't get into that because we'll never get out of here once I start talking about that. But we have them sign all those things. We want to be protected in that manner when we're buying. Now, when we're selling, we're not given any due diligence. If we're selling to investors, that is. We tell them, look, if you're signing this contract, you've already done your due diligence. This is what the earnest money is, and it goes hard right away, meaning it's in effect. And you are buying it as is. It doesn't matter what you find down the line. Now, if there's something significant wrong with the property, we're gonna tell people, oh, there was a triple homicide in that house. Just want you to know, we don't have to do that, but I think it's important. Hey, we had a foundation issue on that property. about 5 years ago, but we got it fixed. Here's the documentation, or the seller did it, but they didn't have it documented, but here's the name of the company. Ricky and I just did a deal where the foundation on the house was anywhere between, he had a number of contractors go out there, anywhere from, I think the lowest one was like 15,000 all the way up to 50,000 to repair this particular problem. But because we had the wherewithal to read the insurance policy, we saw that the seller very wisely, stream quality, the seller very wisely got foundation coverage on his insurance. I mean, you can't beat that. You can't beat that. Now it's just the cost of the deductible to fix the foundation. And now Rick is going to know how to contact the people that did the work when it's time for him to sell it. He'll have all that documentation. Again, it's about reading as well. You have to read it. When you're doing sub-2 deals, things move really, really quickly. It's not your typical closing. They move really. These things can be done in a matter of days, just a few days, depending on, who all the players are in the process. So you have just a small window of time. Let's just call it a week and a half, to read through, acquire all the documents that you have to acquire, like the insurance policy, read through the policy to see what's covered, look at the closing documents if you can get them in a timely manner. But if you can get the bank on the phone, if you can get a statement, if you can get a payoff statement and a recent statement, you can figure everything out from there without having to see everything. But if you can get the package, that's always best, because you know how to move, especially if you're new and you don't have anybody to talk to like me, right, that can walk you through these deals and help you in places where you're uncertain. And again, of course, we have these, and I'm going to end this on a not a pitch fest, but I'm just going to say, if you've got more questions, just inbox me. If you got my number, call me, text me, let's make it happen. I know that I got a bunch of questions that have already been inboxed. I do every week, and I appreciate you guys. I love it. And this was a very active crowd today. Thank you all so very much for commenting and asking questions and just, getting into this thing. And for all of you that are watching on Instagram, make sure you go to YouTube. It's the Jason O. Miles Real Estate Network. And you can rewatch this or see us, subscribe, comment, look at some of the other content. I will constantly be putting these. I do this every Sunday, well, most Sundays. And whatever you want to hear, if there's something special you want to hear, let me know. But if you want to take advantage of this, just this here, I'm going to run it all month. Go into the description, hit the link, get these documents, and take the bonus for the subject to document package as well. It comes with it. You don't have to. So take it. It's literally like a quarter of the price, a third of the price. So take advantage of that. I will be following up with you for those that do, so we can have a conversation. Everybody gets a 30-minute, I call it a 30-minute one-on-one strategy session with you and your partner if you have one. And we go through your business. We talk about what you're currently doing or what you plan on doing or how to do whatever it is you do right now better. All right? So thank you all so much for your time. Thank you for your participation. I hope this was beneficial to you. I know that this information isn't out there everywhere, so it's here for you now. Okay, it's here for you right now. So please take advantage of it and go to the YouTube channel, like the video, subscribe to the channel, hit the little bell. They tell you to hit, show a brother some love. I appreciate you guys. Thank you so much. I want you to have a great night. I know we all got to get right back to it tomorrow. It's time to go to work. So without anything else saying, because I could just keep running on, and I promise I'll shut up. Thank you again so much. Have a great night. I'm going to answer some more questions and go make dinner. Peace. What's going on, friends and family? How y'all feeling today? I hope you're feeling great, doing well. I've had a lot of conversations over the past, I'd probably say about the past couple months, 2-3 months, about people wanting to get involved in real estate and asking how they can get involved in real estate given all that's going on with the economy. Well, you either have a lot of time, which means you don't have the money, or you have a lot of money, which means you don't have the time. And they want to know how they can get involved in real estate. Some of them have said, look, man, what do I need to do to just get into a deal, right? I don't really have the time to do all of that. So we've just invested their money in some of the deals that we do. So I'm here to open the invitation to all my friends and family that are watching this right now. If you're interested in getting involved in real estate and you simply don't have a ton of money or you don't have a ton of time, maybe you only have, $5,000, maybe you have $100,000, I don't know. But if you're interested in investing in real estate deals passively, truly passively, just reach out to me. There's no link, this isn't an ad. Just DM me and let's have a conversation. We've got deals right now that we can fund. Right now, as of right now, multifamily as well as single family, deals that you can be in as little as 6 months and as much as 2 or 3 years, depends on the scenario and what your particular investment strategy is. All I can say is let's have a conversation. So if you're interested, friends and family, just reach out, let's have a conversation.